My name is Tino Cuellar, and it is my pleasure to be chairing this panel this morning. As you know, this is the first of two panels that will be dealing with issues and dilemmas associated with problems of campus sexual misconduct, this one focused on procedures. It's sometimes been observed that you need four things for a great panel. First, our terrific panel members, and we are fortunate to have Professor Michele Dauber, Mr. Andrew Miltenberg, Professor Deborah Rhode, and Professor Jacob Gersen. So you know it's going to be good. Their bios are already with you, so I won't go into the details, but I can tell you, I know it will be a fascinating discussion. Welcome to the four of you. Not only are they thoughtful and interesting, but they're also great because I know they're going to stick to the 12 to 15-minute time limits, so we will have plenty of time for questions. Second, one needs a compelling and important topic, and we certainly have that. Observers describe the 2011 Dear Colleague letter from the Department of Education as a substantial shift in administration policy in this area. And even more important, university procedures in this domain are extraordinarily and profoundly important at the human level, both to victims and folks who are accused, certainly to people who are part of the campus community and to the public at large. Third, to channel the late political theorist Judith Cuellar, one of my heroes in political theory, it's important to be wary of too much agreement. And I suspect we're going to have some disagreements. Last but not least, you need a moderator who will be quiet and let others talk, and that's what I'm going to do right now. So what we're going to do is we're going to start with Professor Michele Dauber, then we're going to go to Mr. Andrew Miltenberg, then we'll have Professor Rhode, and then Professor Gersen. Professor Dauber, the floor is yours.
Thank you, Justice Cuellar. Thank you, Michael McConnell and the Stanford Constitutional Law Center for hosting this conversation and for inviting me to participate. When I was initially approached about this conference, I will admit that I was a little bit apprehensive because the terms of this discussion have become quite polarized very quickly, and at this point it seems like there isn't much that advocates on either or many of the sides agree. I really don't like the fact that it's become so polarized, and so I wanted to start out by working on building some agreement among us in this room, hopefully, and putting forward what I think will be a really uncontroversial proposition, and then see if we can build out further agreement from there. So this is my attempt at levity on a serious topic. But actually, everyone loves cat pictures. Actually, what I want to discuss is, I hope, not really a lot more controversial than that, and at least that is what I hope I'm going to convince you of. So what I'm going to do with my time is I'm going to offer what I think are some fairly modest ideas regarding information and transparency. So first I'm going to talk about why I think we need more information. Second, I'm going to talk about the kinds of information and data transparency that I think are essential to come to good public policies on this subject. And finally, I'm going to, with the time I have left, give some concrete examples from my own experience trying to get information about this subject and to make that information publicly available. So the first thing that everyone asks me in this area is, who is doing this right? When I talk to anyone working in this field, they say, well, who's doing it right? Who should I be talking to? And the answer is, I have no idea. I have a few anecdotal things that I've heard at conferences or from friends or at other institutions. I've looked over the policies of a lot of schools, but really, how would I even know? What does doing it right even mean? What are the metrics? How could I look across institutions and even find out? So schools are looking for models. No one really has any idea. I have a basic sense that Dartmouth, for example, has a good policy, but I could not prove that. And it's not even easy to find out what's happening school by school, let alone find comparative data. And this is a serious inhibition to forming some idea of what best practices are, because the idea of a best practice carries within it the notion of empirical data that supports that judgment. And if nature abhors a vacuum, higher education consultants really abhor a vacuum. And the lack of data has provided a space for a cottage industry to form, which is really not a cottage anymore, in Title IX consulting. Are they selling practices that actually work? Probably not, but who knows? Lying, behind a lot of the conversation in this area is the idea that schools cannot be trusted. So one charge that is heard from all sides of this debate is that schools can't handle these cases. Last week, in fact, I was on a panel with Gina Smith, who's a very famous and extremely expensive consultant in this area, who has a very detailed plan to establish regional adjudication centers that will remove these adjudications from the schools entirely on the theory that schools will never, ever be able to do a good job adjudicating these cases. Basically, it's hopeless, and the phrase that you hear the most is kangaroo court. According to published reports, Smith is loathed by victim advocates who consider her a profiteer, who enables schools to evade their moral and ethical responsibilities. But earlier that week, I was part of a conference of faculty advocates for survivors, and the consensus was basically exactly the same. Schools are running kangaroo courts, and they can't be trusted. Now, that might be true, but in my opinion, we should not rush to that conclusion. And I'm going to talk about why I think we shouldn't do that. For one thing, there's no obvious limiting principle. So if schools can't adjudicate sexual harassment among students, then what else can't they adjudicate? Given the factual assertions being made on both sides, there's no reason to think that officials who allegedly mishandle evidence, can't follow their own rules, can't write or follow decent procedures, misinterpret evidence, fail to collect evidence, mishandle evidence, act from personal bias, are racially prejudiced, discriminate against gay and transgender students, and come to inept or baseless conclusions, and so forth and so on, are going to do a bad job where the subject is student sex offenses, but somehow do a good job when they're dealing with other kinds of student disciplinary infractions. So this is a particular worry to me where the offenses are similar in nature. For example, in any case in which there are no other witnesses, or where it's racial harassment or anti-gay or religious violence or harassment, which are, by the way, also civil rights issues, or fraternity hazing, which often has a lot of similarities with sexual offenses. There's just no reason to think that it's going a lot better. And the argument that we should treat sexual assault as somehow entirely different or a thing apart because sexual assault is just more serious than anything else, and we can call this the, quote, getting branded a rapist argument, I just don't buy that, because I think having a record for academic dishonesty, fraud, physical violence, firearms issues, racism, anti-Semitism, these are all basically as bad or worse in many cases for your future. And I don't find the sex is different argument particularly compelling. I personally would rather be found responsible for sexual harassment than anti-Semitism, for example. For one thing, you don't have the "it was just drunk sex" explanation for why you painted a swastika on the side of the Hillel building. So it's probably more serious and damaging to your long-term career prospects, to be perfectly honest. And when I was chair of the Board on Judicial Affairs at Stanford, I was repeatedly contacted by an alumni named Bob Ottley, who was a lawyer who represented students who'd been accused of cheating. And he wrote a 50-page, single-spaced report on what he saw as the chronic incompetence, unfairness, and utter travesty of the Stanford judicial process. I mean, he virtually stalked me. I got phone calls, I got cards, I got letters, I got calls on my cell phone, I got calls on my home phone. He showed up in person, the number of emails. He was just relentless. And this was not about sex. This was about cheating. This was regarding a judicial process that used a beyond a reasonable doubt standard, the highest you can imagine, and had a full-on judicial affairs hearing with a 6-person jury. And this is what the advocates for the accused want, and according to Bob, it wasn't any better, and it was probably worse than the sex panels. So he was definitely trying to create the same sense around cheating allegations at Stanford that some advocates for accused students are now trying to create in the sexual assault arena, but maybe because the topic isn't as sexy, literally, he didn't get the same kind of traction in the media. But according to Bob, it wasn't any better. And so I don't think he would think that this is a problem that's limited to rape. So there's no horizontal limiting function. And there's also very little vertical limiting principle. So what about faculty harassment? If schools can't competently adjudicate student-on-student harassment, how will they adjudicate faculty harassment of other faculty or of staff or of students? Are we really ready to conclude that schools cannot competently investigate anything to do with sex for some reason? And how far does that ineptness go? If Stanford and Harvard can't do this competently, then what about K-12 and private schools? Are we ready to say that schools can't competently investigate disciplinary allegations? Now, it might be true. All of that might be true. We might need a radically different form of fair hearings for school-based discipline than what we're used to. Up and down the line, stretching from kindergarten to retirement, not limited to sex, but basically without limit, public, private, faculty, student, for some set of issues, including sex and not limited to it. That is a big idea. And I think people have not thought all the way through to its logical conclusion. And before we would conclude that, we would need to be cautious. There are a lot of things that we don't know yet. And we would be deciding to go down a potentially extremely consequential road, which we might want to do. But we would be deciding to go down a potentially very consequential road on the basis of extremely limited information. So before we would make policy in this space that would head in that direction, we should first ensure that we're acting from a place of very solid data and that we have the benefit of comparative data with other schools. So what do we need to know in order to make good policy? And the problem is that we just basically don't know anything. There are several different kinds of basic information we don't know. We don't know basic facts. What are the policies in place at each school? What's the definition of sexual assault? How does it differ across institutions? What's the norm? What about disciplinary policies? Do some schools use panels and others use investigators? What are the features of each policy? Are there big commonalities or is it just all over the place? The second kind of information that we don't have is how much sexual violence is there really? There is a lot of disagreement about this. We don't know. One of the ways that we try to find that out is through the use of an anonymous climate survey, but we need common standardized metrics and a single survey taken by all schools and reported to the government and published in a transparent way on the internet. And the third kind of information that we don't have is information about how these policies are actually implemented in practice. How many complaints, how many adjudications, how many findings, what sanctions, how many informal resolutions there are, how many days did the investigation take, whether the sanctions are changed on appeal. We don't know any of this. Right now, the only school that I know of that is doing a good job with this is Yale. That doesn't actually mean that that's the only school that's doing a good job with this. It's just serving to underline, I think, my point on the lack of transparency. I happen to know about Yale because I had a friend who was on the university-wide committee that decided to make this data public. And I encourage anyone who hasn't seen Yale's reports, which they issue every 6 months, on their Title IX process to take a look at their website because it's really quite remarkable the amount of data that they publish and make public. And that brings me to my fourth thing that we don't have, which is transparency. Even when all the information is available in theory, it's almost never accessible or available in fact. Yale, again, posts all of this on their website, which is great. This is just one slide from 70 pages or so. But I knew about it, like I said, randomly. Transparency around adjudications is just critical. So long as the process is completely secret, we can never really trust it. And a lot of the distrust that we have on both sides of this issue are because of the lack of information. We obviously have to protect student privacy, but we need properly anonymized aggregate data that complies with FERPA, and that should be released, and the public should be able to review it. We just can't know if our procedures are working without this kind of data. We have our anecdotal cases of alleged failures, which I will call sad raped girls and railroaded boys. We have our anecdotes, we have our memes or our tropes for this, but we don't know if these are anomalies or if they represent systemic failures. It's often not easy to get this information even when it exists. In my own experience, this is me trying to get this information, I have had to try to get information both internally at Stanford and also comparative data across institutions. And in both cases, I'll show you very briefly, it was very hard to get information. First, I'll show you an example of policy information. This probably represents 50 or more hours on my part just to find out what Stanford's peer schools do, whether they use a panel for adjudicating sexual harassment, and if so, how the panel's configured and whether it requires a unanimous vote. And in this case, Stanford had decided to move from a 5-person supermajority to a 3-person unanimous panel, and I just wanted to know if anybody else did this. I just had literally no idea. And I found out, no, basically only one other school does this, and that's Duke. So, 50 hours. This one, I was trying to find out whether how other institutions just define sexual assault or their most serious category of sexual violence, because Stanford utilizes an extremely narrow definition, and I just wanted to know, what do other schools do? Is our definition typical? Is it atypical? And I found out that it was actually quite atypical, and also a recent innovation for Stanford, which had used a much broader definition up through 2012 when it started narrowing it. And just because, by the way, it's unusual doesn't mean it's wrong. There's lots of things that are common, like heroin, that are not good. So just because it's common doesn't make it good, and just because it's atypical doesn't make it bad, but it's also important information to know. We should know what other schools are doing in this space. It's a piece of information that should be considered. And in this case, this was a very useful exercise because it sparked a community-wide conversation that has led to rolling back this narrow definition. And let me show you one. I'm going to skip ahead past this and say that for policy implementation and adjudication, this is the space in which the least is known. And I first started collecting this data in 2010 when I was leading an effort here to revise Stanford's policies on sexual assault and sexual harassment. And then I was collecting data to try to find out if what we had done worked. Because one thing we just don't do is program evaluation. We have a lot of things changing very rapidly in response to litigation and political pressure, and not a lot of data being collected to see whether what we're doing is working. And so we have an almost hysterical policy-making situation, in my opinion, with very little program evaluation. So I was trying to evaluate the program that I had done, and what I showed was that before the reform, we had only adjudicated 2% of the cases that this is adjudications, this isn't findings of responsibility. Findings of responsibility was 1% or whatever. We had only adjudicated 2% of the cases that were reported under the Clery Act. And after the finding, that went to 22% in the first 3 years. So I said, well, we accomplished one of our goals. I don't know if we accomplished all of them, and I also don't know if we set other things into motion that were not necessarily good. This is just one metric on one change. So in conclusion, I want to say that we don't know nearly enough. The information cost is too high and the transparency is too low. We need good data to be able to make good policy in this space that's supported by relevant stakeholders, and we need mandatory disclosure requirements that are part of legislation, hopefully at the federal level, but some of this is already starting at the state level, that will require the use of common metrics and common measurement. Because the problem is there's also things we don't know. As we start to make changes and we make them in rapid succession without pre and post measures, without an agreed upon set of metrics, and without a way of knowing whether we're being successful or even an idea of what success would be, apart from some sort of very contested ideas about that, what we're going to get are possibly unknown unknowns, right? We're going to stumble off and we're going to have things that we couldn't even have anticipated. So that is my presentation, and thank you for allowing me to participate.
Thank you. Mr. Miltenberg.
Yes, thank you for having me. Professor Dauber points out something that is very interesting, and that is the lack of uniformity and the lack of consistency between various universities makes it very difficult to come up with a specific policy, and makes it even difficult to understand where universities are headed. But from my experience over the last 3 years, and I've represented close to 100 students at, by my last count, 50 different universities in disciplinary hearings, many on the list that were pointed out. I too can tell you that the information isn't anecdotal, and I'm going to share some of my in the trenches, real life, boots on the ground experiences with you. And before I get started, I do want to point out that portions of what I say describe real events and real interactions, and I don't want it to seem prurient or uncouth, but some of the language that I use will be the language from the various matters that I've handled. And I think that language and those interactions are important because one of the things that panels are missing, and I try cases, I've spent 26 years as a business litigation attorney. I do not have a book. I have not studied criminal law. I do not practice criminal law. I have not taught. And I don't have a particular political agenda, and I've never studied constitutional law other than in law school some 28 years ago. What I do is try cases in state court, federal court, before arbitration panels. And I'm going to use words like shadow court, star chamber, kangaroo courts. And those words may sound operatic and they may sound theatrical. And before I start to use them, I think it's important to know a little about me so you can see the lens through which I view these cases. I'm 51 years old, a father of 3. I'm a lifelong New Yorker. I have 2 little girls and a son. And if anyone touched either of my little girls, I'd need to hire one or all of you as my criminal lawyer. But I also have a son. And what's going on at universities, at the disciplinary level, is very frightening. I remember walking into a classroom on my first year of law school, and on the board was written, "Justice is the process, it is not the result." And with that in mind, I want to turn on its head everything that we all believe we know about due process, about the Constitution, about the protections that we've all come to know and rely upon in those protections that are a cornerstone of a free society, because they don't exist inside the disciplinary panel. What does exist inside the disciplinary panel is a complete lack of consistency from university to university, a lack of consistency within the same university. I've handled 6, 7 cases at Yale. I've handled almost a dozen at Columbia University. I've handled almost a dozen at NYU and half a dozen at Wesleyan. And I can tell you that one school is now sort of getting it right, and that's Yale. And I'm a humble guy, but I'd like to think I had something to do with it because the first 4 cases I handled at Yale were a bloodbath. And it took an awful lot of pushing back, and it took an awful lot of my clients saying to me, "You can't talk to the people at Yale like that." And, you know, unfortunately, you have to, because what I'm going to describe to you is in fact frightening. And I'm going to give you some real-life examples. And then I'm going to tell you why those examples are frightening. So there's a couple that's dating for a long time at a well-known Northeastern university, and they have a very mercurial relationship and a very sexually passionate relationship, and one they've documented, oddly enough, in many different ways. And it's a young couple, and dating for a long time by young couple standards. And one night the young man gets a text, and that text is, "Meet me in the newspaper editor's office." They were both on the newspaper. "I want to fuck you on the editor's desk." And they then proceed to meet and have sex. And during that sex, they try a number of different things. And they go on and date for weeks after that. And then the young man goes to a fraternity formal with someone else. And they break up. And that's in March. And the rest of the year goes by with nothing. And the summer passes, and they go back to school. And in October, young lady says, you know, I realized that one of the things that we did when we were together on the editor's desk, I'm not comfortable with. And that becomes the basis for a complaint. And then what ensues is not an investigation. What ensues is an interrogation, where this young man who was on a scholarship, who was the president of the student council, who was the student liaison to the board of trustees at the school, thinks that if he just tells the truth to the investigator, it will all be okay, because of course the school is merely trying to understand what happened, right? No. The school, in this case, the one I'm speaking of, and in virtually every other case that I've dealt with, and this is not anecdotal, I live this every single day, acts as a prosecutor. And by the time the interrogation was over, and by the time the Title IX investigator, a former rape counselor, were done with their report, there was very little to do. And I went to a hearing, and after about 20 minutes of the hearing, I was asked to leave. And this wasn't my first hearing, but what was going on was outrageous. And as it is, I have high blood pressure, and I needed to take a blood pressure pill at that meeting. And he was expelled within 20 minutes by a panel made up of the head of the Women's Studies Department, a female volleyball player, and someone from the Food and Beverage Department at the school. All well-meaning, well-intentioned people who had no business adjudicating a factual scenario that needed to be deconstructed and then reconstructed in a fair way, because at the end of the day, there were only two witnesses to what occurred. And he was within 30 minutes expelled and walked off campus. And he now is back with his parents. He's working in a car dealership. He can't go to school anymore because he can't afford it. And even if he could, good luck finding a school that will take him. And he was a very promising young man. And this is not one story. I could keep you all in this room, nonstop, for several days on this. 3 years ago, I had one lawyer in my office, me, working on this. Now I have 4. Every case that comes in, not everyone, but the majority of them, I look at, not as a criminal lawyer, not as a constitutional lawyer, not as a civil libertarian, not as a guy with an agenda, and I look at it and I say, my God, what the hell is going on? And I listen to these stories, and oftentimes we all have an inner barometer by which we can tell when something went wrong. And I listen to these stories, and I have to tell you, from the beginning of the case to the end, the majority of them, I don't know where it went wrong. You have young people who, sometimes fueled by alcohol, sometimes not, think that there is a consensual encounter. The majority of these cases have no violence. There's no rape kit. There's no ambulance. There's no law enforcement. There's 2 kids who may not be well equipped from a maturity or experiential standpoint to understand the interaction, the nonverbal cues that each of them are giving off. And that's why, and because the fact that the ramifications are so significant, an expulsion, forget it. You're not going to law school, you're not going to med school, you're not going into law enforcement. I've got a young man whose mother is a judge, a federal judge. It's over for him. I've got a student whose mother is a U.S. attorney, an assistant U.S. attorney. It's over for him too. His ROTC scholarship, gone. And I'll digress for a second because in that case, the school investigation team is cooperating with law enforcement. Forget FERPA. Forget the fact that the interview he gave to the Title IX investigator was not Mirandized. He didn't have a lawyer present. It's being shared with local law enforcement. Offensive on many, many levels. What goes on when the investigation starts is as follows. Someone comes to your room or sends you an email. You need to come to the dean's office. They go there. They're 18, 19. They think, well, this is okay. I'll just tell the truth. Yes, we both had 2 beers, and yes, we met at a fraternity party, and she's in my poli-sci class, and yes, she came back to my room, and yes, we had sex. And okay, that's what college kids do. And we had breakfast the next day, and we saw a movie the next night, and 2 months later, I slept with her. These are real cases. I'm not making this up. 2 months later, I slept with her suite mate, and a month after that, I was charged with sexual assault. And from that ensues an investigation that may or may not include all the witnesses. The investigator may or may not keep field notes. Their notes may be written down days later. They may or may not take down all of the information. They may or may not look at texts, the ones like, please meet me in the editor's office and fuck me on the editor's desk. They may not look at social media from the next day, which says, I had a great night. Thank you for seeing me. I hope to see you next week at the fraternity party. They likely won't look at that evidence. What they do is write up a report. You may or may not see that report. You may or may not have time to take notes. You may be invited to the dean's office and they may say, you can't take a screenshot of it. We're not going to give you a copy. You have 1 hour to write down whatever you want. And the hearing's tomorrow, and the report's 30 pages long and includes medical evidence. This is not what goes on at the panels, and I'm giving you a composite of 3 years and close to 100 experiences like this. The school is not acting as an objective fact finder. The school is acting as a prosecutor, which leads me to a recent case that I've handled, and I know I only have 2 minutes. At Wharton, 2 weeks before graduation, my client was pulled out of graduation and said there's an investigation. The girl you met on Tinder that you spent the night with and had breakfast with the next morning that you didn't call back 2 days later thinks that you raped her. Okay, so there's an entire investigation, and at the last part of the investigation, I hand the Title IX investigator a forensic toxicology report and 2 polygraphs taken by 2 very reputable former FBI agents, 2 separate ones, and a toxicology report. And this is what I get. I'm not looking at that. And I say to the Title IX investigator, well, let me understand. We want to have the full breadth of the truth, right? I mean, you're trying to get at the truth. Don't you want to consider these things? I'm not looking at it. And then I said, well, if you're acting as an advocate and don't want to look at my evidence because you're an advocate for the school and you don't want to see what I have to say, that's okay. But then treat this as an adversarial process. Allow me to cross-examine someone. Allow me to see the evidence. Allow me to speak to someone other than you. No. We have our report. But you don't have your report. You have what you want the report to say. You don't have everything. Mr. Miltenberg, I'm not taking it. And that ended with me saying, I'm leaving it here. Look at it, don't look at it, but trust me that a federal judge in Philadelphia will know that you pushed these across the table back at me. And consider that when you decide that my client can't get his diploma. And that ended with a 2-year suspension. He finished all his credits. He lost his job at a bank. He is living in his parents' house. I don't know if he really did force this young lady to have sex. We'll never know. And I don't know that he did anything right or wrong. But I do know that the process in that case and every other one that I've had doesn't feel right, it doesn't taste right, it doesn't smell right, and if it was anyone in this room, you would have wanted me to do what I did there, and you wouldn't have been happy with the result. And that's why, regardless of what process we ultimately agree on, and I leave that to people much smarter and more experienced in public policy than I am, whatever we agree on must include a full and fair process where the breadth and depth of evidence, the breadth and depth of the full context of the relationship between the parties, and the understanding that it is, in fact, an adversarial process, and let's not call it an objective process. If we understand and allow for that, then any process, regardless of the result, is acceptable. Thank you.
Thank you, Mr. Miltenberg. Professor Rhode.
Thank you. Well, let me begin with a point of agreement. I wish I had Michelle's cute kitten slide to put up, but just visualize it for a second. And I'm going to agree with both of my predecessors. First, stories are important. Campus sexual assault has been with us for decades. But what has gotten it onto the national agenda for the first time is stories. Stories by survivors who've been courageous enough to come forward, and sophistication in using legal mechanisms to force some accountability. But stories have their limitations, and that brings me to Michelle's point. Unless we know whether the stories are typical, we're going to be in the realm she described of the unknown and the unknown. And the lack of transparency around this issue makes it very difficult for us to make sensible policy in the area. What do we know about the nature of the problem? Well, we know that for the vast majority of individuals who report experiencing a sexual assault, they don't report it, either to the campus officials or to law enforcement authorities. Best evidence, only 12 to 13% of students report. Reasons include fear of reprisal, not wanting others to find out, not knowing how to report, lack of proof, expectations of dismissive treatment, ostracism and vilification by the peers of the individual who is accused. Those expectations are not unfounded, and the experience of not being believed can increase the trauma. I too could keep you here, perhaps not as long as Mr. Miltenberg, but for a good period of time with stories like the Amherst student whose sexual assault counselor told her that pressing charges would be useless. He's about to graduate. There's not much we can do. Are you sure it was rape? It might have been a bad hookup. You should forgive and forget. In a similar case, at Occidental, an administrator reportedly told a complainant not to worry about safety because she had met the accused rapist, and he didn't seem like the kind of person who would do that. One New York Times account of a campus rape incident put the takeaway in the title, "Reporting Rape and Wishing She Hadn't." Victims are often victimized twice, once by the assault, then by the process of proving it. And for every story that Mr. Miltenberg has of a railroaded accused individual, I could give you a counter story. Both are true, and neither should be diminished. What we do know, again from the best available data, is that very few of the people who do come forward and report get anything close to what they consider to be justice. Only about 7% of those who report their assault to the campus see an arrest, resulting only 4% a conviction. And those accused of sexual assault often find that they have no way of knowing whether the sanctions are sufficient. One report by the Center for Public Integrity showed that only 10 to 25% of students found responsible for campus sexual assault are expelled, and that sanctions can be as minimal as probation, suspension during a summer term, requiring the offender to write a letter of apology or watch a brief educational video. Those accused of sexual assault also have a valid complaint for the lack of procedural protections. And according to the founder of Families Advocating for Campus Equality, in their rush to judgment, colleges have now substituted one class of victims for another. That needs to change, but it's impossible to make sensible changes unless we know more about how institutions have responded. Again, Michele's point. What is clear, at least from the limited data that we have, is that even the best intentions of by members of adjudicative boards go awry, partly because they're ill-prepared for the role. Senator Claire McCaskill's survey of 440 institutions found that a third failed to provide basic training in cases involving student sexual assault. More than a fifth conducted fewer investigations than the numbers that they reported to the Department of Education. And although experts agree with Michele that annual confidential surveys of students are one of the best ways to get an accurate sense of campus sexual assaults, only 16% of institutions are now conducting those surveys, and often they're not using common definitions or metrics. We know almost nothing about the adequacy of the brief rape awareness programs that are so common in campus outreach areas. We also don't know enough about how to implement effective responses. We know that over 100 institutions are now under investigation for Title IX violations in handling sexual assault claims. But if history is any guide, most of those are not going to result in federally mandated reforms. In one survey of complaints between 1998 and 2008, the Department of Education ruled just 5 universities out of compliance, and only 24 resolved the complaint with a federally mandated plan to change. And part of the reason may be, for the low success rate, may be the resource constraints that are preventing full investigations. The Office of Civil Rights now has a quarter fewer staff members today than it did 20 years ago, and it's handling 3 times as many complaints. Also, the sanctions that are available to the Department of Education are somewhat inadequate. Their only sanction, really apart from the threat of sanction, is the cutoff of funding. And that's a kind of nuclear option that is none have been willing to exercise. So as one petitioner put it, Department of Education resolutions negotiated often lack teeth. They're all carrot and no stick. So what can we do? And first and foremost, I agree with Michele that the answer is greater standardized data across all the range of issues that she mentioned. Also, a step in the right direction, I think, is the proposed Campus Accountability and Safety Act, which would require collection of some of that data, designate confidential advisors to coordinate survivor services, train personnel involved in sexual assault related services and procedures, no longer allow subgroups within the university, like athletic departments, to handle complaints of sexual violence, and better coordinate efforts with local law enforcement agencies. The bill would also fine schools up to 1% of their operating budget if they fail to investigate reports of sexual assault, and increase penalties well beyond the current rather minimal level. Obviously, we need additional funding for the Office of Civil Rights, and we need additional pressure through that office to get schools to both conduct and publish surveys to assess not only the prevalence of sexual assault, but the effectiveness of remedial strategies. We know extremely little in one area that Michele didn't mention, but that's absolutely critical: what works in violence prevention. Huge numbers of institutions are now spending a lot of money on interventions where we have absolutely no research to determine effectiveness. And more sophisticated assessment of multi-pronged preventive approaches should be a priority. And among those areas that need additional concern is alcohol abuse. It's the elephant in the room in so many of these cases. About 100,000 students a year experience sexual assault while under the influence of alcohol. And we know very little about what makes for effective interventions on most campuses, and it isn't a sufficient part of the dialogue on sexual assault and prevention. If we're going to make significant progress in this area, yes, we need stories, but we need stories of institutions that are doing it right as well as those who are doing it wrong. And there, Michele is absolutely correct. Those of us who work in this field have had a hard time coming up with good examples of best practices. And we're not going to get there unless we have the kind of institutional accountability, both for the failures for accused students, but also for survivors of campus sexual assault. So here's a plea to those of you who've cared enough to show up in this room. We really need to build a constituency that's going to demand that accountability from Congress, from the Department of Education, and from campuses themselves. Thank you.
Thank you, Professor Rhode. After we hear from Professor Gersen, I'll ask a brief question, and in the meantime, I'll invite members of our audience who want to ask a brief question to line up at the mics, and then we'll go to you. Professor Gersen.
Thank you. Can I have those slides?
Oh, of course. I'm so sorry.
No, not your responsibility.
You sure you don't just want this one?
Yeah.
Because I think
He might have his own kitten.
I think it makes people calmer.
I too would really like to find some common ground, but I think it's important to clarify where there is conflict and disagreement also. And I simply will not and cannot sign on to pictures of cats.
There's one in every room.
I fear there's several in this one. Thank you, everyone, for coming and for having me. I come to the field from administrative law, so my perspective is a little bit different. And that's really the law of what the government can do and the way the government can do it. Focused chiefly on what administrative agencies, that is, the bureaucracy, can do, and the structures and process that we ask of them and require of them in order to produce desirable, good, effective, and legitimate action. And one of the interesting things about this area is that the Department of Education and the Office of Civil Rights have chosen procedure. This is what we do with agencies. We lay out elaborate procedures, hoops for them to jump through. And what OCR has done is essentially take that exact tack, take the rules that are used to regulate themselves, and use procedure to try to structure the conduct, to spur action, and to regulate exactly what is done in universities across the country. And so there are those of us who think that the way the Department of Education implemented these policies, these rules, these requirements were unlawful. That is to say, ran afoul of those procedural requirements in the Administrative Procedure Act. Nevertheless, they have embraced procedural requirements as the chief way to effect change and respond to this problem of sexual violence on college campuses. Now, we've heard a little bit about the procedures that are required already, that the schools have adopted and implemented, how they're good and bad for victims, for perpetrators, across the board. But I want to pause and try to nail down the actual source of law, the source of law for these requirements. Because in our public debate, we go Title IX, and then we go campus sexual assault. And actually, there's a lot of legal work in between those two ideas or concepts, so I want to just try to fix the discussion so we can talk about it. Almost all of the campus adjudications are being implemented to enforce or administer Title IX. And that's a very simple statute. Many of you are familiar with it. No person in the United States shall, on the basis of sex, discriminate under any educational program. I can't see the end of it, but I'm sure you can see.
Receiving federal financial assistance.
Receiving federal financial assistance. Oh no, that didn't happen. That didn't help. The idea is a simple ban on sex discrimination in higher education. Widely embraced law, very powerful law, sex discrimination, 1972. Fast forward several years, and we have the document that is really at issue in a lot of the fights, public fights, legal fights, about, you want me to move?
Yeah, why don't we switch places so you can see your slides?
Okay. This is a disruptive tactic, I can say. And so in 2011, the Department of Education, the OCR, issues a Dear Colleague letter. And what that is in administrative law terms, it's a guidance document. So if you're an agency, you can do a bunch of different things. You have authority from a statute, and you can write down new rules. And if you write them down, they become law, and then you go out and enforce them and fine people and put them in jail sometimes, and you make regulations. Or you can just go and enforce the statute, haul people in and enforce in a proceeding. Or you can issue guidance. And a huge part of what the bureaucracy does today is issue guidance. This is how we think the law should be interpreted or followed. And it's not, it's not law, but it's what we think the law requires. And as we, the agency, go out into the world to enforce the statute, here's how we're going to think about it. And here's how we encourage you, the regulated parties, and the world to think about it too, how we encourage ourselves. So they say, if a school knows or should have known about student-on-student harassment that creates a hostile environment, Title IX requires the school to take immediate action to eliminate the harassment, prevent its recurrence, and address its effects. And when OCR finds they have not taken prompt and effective steps to respond to sexual harassment or violence, they'll seek appropriate remedies. And they may initiate these proceedings, this so-called nuclear option that Professor Rhode references, the elimination of all federal funds. Now, whether that's, a giant stick or no stick at all, we could talk about, but that's what's at the end of the day. So what must a school do to comply with this guidance? Well, a recipient of federal funds has to comply with all federal law. And if they don't, the agencies that administer those funds can take it away. And that's all or everything the department is talking about doing. So they must disseminate a notice of non-discrimination. They have to designate an employee to coordinate efforts. But at issue in most of these cases right now, these procedures we're talking about, is the adoption and publishing of grievance procedures, providing for prompt and equitable resolution of student and employee sex discrimination complaints. Okay? These are grievance procedures that must be prompt and equitable, provide for prompt and equitable resolution. This is the key language. Now that language, prompt and equitable, is not in the statute. It's from a prior Department of Education regulation that dates back many years. B is the one we care about, 34 CFR 106.8. Aren't you happy you came in today? Recipients shall adopt and publish grievance procedures providing for prompt and equitable resolution. And so over time, what happens is the prohibition on sex discrimination is come to understood to include a prohibition on sex harassment. This happens in the courts and elsewhere. The prohibition on sex harassment is understood to include sexual assault or sexual violence. And then the grievance procedure, which must provide for prompt and equitable resolution, has to sufficiently or adequately respond to allegations of student-on-student or employee sexual assault, sexual violence, sexual misconduct. So this is the legal background that is operating when the schools adopt these procedures. Okay. Now, the Department of Education has a lot to say about what makes for a prompt and equitable procedure. And this is just some of it. There's a long document, we can talk about it later. But at a minimum, you get notice, for example. You have to have a reasonable time frame. You've got to have a reliable and adequate and impartial investigation. Application of procedures to comply. All these things which seem actually quite reasonable. So you could object to the way the agency did it, but all these requirements for a prompt and equitable resolution seem largely unobjectionable. And then what we see on the ground, I'll get back to these, are the procedures in the anecdotes, the procedures that Andrew Miltenberg is talking about, and Professor Dauber is talking about, and Professor Rhode is talking about, that are essentially maligned from all sides chronically, except maybe Yale. And there's a kind of puzzle, which is what exactly is going on? That's to say, how do we get from a place where the Department of Education has taken on this problem, articulated procedural requirements that are being implemented by schools, but in a way that seems wildly out of step with the basic principles of the requirements. So I think we're here, this is speculation, but I have a little to say. So I think we're here for three reasons. First is that whether you like the specifics of what the OCR has said, it's clear that schools have to be in this business. And so when we say there are now 100, 200 complaints, investigations?
250.
250 investigations of institutions of higher education for the failure to comply with Title IX requirements. These requirements, it's clear that schools have to be in this business. Schools understand this, and they are moving adequately or not, competently or not, to respond to these problems. Second, the people who implement these policies are people who implement these policies. And they come with all the imperfections that you or I or we do, and all the susceptibility to structural bias or individual bias or a lack of expertise, or all those things. And when they implement those procedures, let's say there's been imperfection. Not through ill will necessarily, but just through the nature of human reality. Okay. Third, one second up first. Third, if you're found, if the school enters a finding of non-responsible, that's to say not guilty in colloquial terms, that opens the school up to an investigation by the federal government. Many of these investigations, at least the early ones, and I think the ongoing ones, but I'd be happy to be corrected, start because of an individual allegation of inadequate response to an allegation of sexual misconduct. It's a single or a couple of instances that trigger an investigation. And it is a single instance of inadequate response, insufficient response, that can start that investigation going. Schools recognize this, and both for PR reasons, and I happen to believe because of the funding issues, but we could talk about that and disagree about it, that's an issue. And so whether you're an individual in the room or an administrator hearing an appeal, there is, I think, a recognition, or there just has to be a recognition, that there's an asymmetry in this process. A finding in one direction opens you up to investigation liability, and a finding in the other does not. That is not good for either side of this process. It's not good for the adjudicators, it's not good for the complainants, it's not good for the defendant, it's not good for anyone. It's a structural feature. And just to hammer the point home, those of us who teach due process and administrative law, we know that like a surprising number of arrangements are actually constitutional that are deeply objectionable. But the one thing we know is that there's a pecuniary interest, a financial interest in the outcome of an adjudication that the adjudicator has. That's not okay. So if I find you liable and I get money, and I find you not liable and I don't, well, that's not okay. And this system just doesn't look radically different from that scenario. I think it ought to be adjusted. Now, to point out a problem without a solution, in this area isn't that much. So this is a problem. There are lots of others, but I do want to say a word about what I think we might do from here. Okay, you could say, just get schools out of here. They're bad at it. Victims think so, complain, everybody there's bad at it. But that's not going to happen. It seems very, very unlikely. And moving it off-site to private investigators or private adjudicators who the school's going to pay doesn't seem particularly great either. Private arbitrators aren't especially unbiased. And that doesn't seem terrific. You could legal it up. That is to say, bring in extremely capable lawyers on each side and make these adjudications like criminal trials, for lack of a better word. I think even if you were to do it, we have this question about whether that's good or effective. I don't really know. It doesn't seem great. And even if it were, it is unbelievably expensive. Harvard Law School has done something like this, and it is unbelievably expensive. And when we say institutions of higher education, we mean all institutions of higher education, 3,000 of them or so, community colleges. They cannot possibly run that system as a way of dealing with sexual misconduct. So if the schools are there, and you can't just legal it up, my basic view is we need to start to establish a set of, for lack of better words, administrative or sexual misconduct procedures. And that will come in part from the information that we are lacking, in part from the data that we are lacking. And whether we call it a code or a set of rules or norms, standards of evidence, I think we need to develop those, and that's obviously part of the problem. Now, I just want to make one thing explicit that I think has been implicit in our discussion so far. We come from a spot where there was a kind of informal rule of evidence in these cases, both in universities and elsewhere, and that was victims always lie. And so when these allegations came, they weren't believed, and they were dismissed, and there was no response. Inadequate from cops, inadequate from universities, inadequate from the criminal justice system. That's the line. And a perfectly sensible response is always believe the victim to compensate for that. And there are people who believe each of these things. Victims always lie, always believe the victim. And if you believe either of those things, just because you believe them or because of ideology or whatever it is, then all the rest of this doesn't matter. All the adjudicative process is just cost. It doesn't matter. You know the answer when you start. As biased adjudicators, it doesn't matter. You know the answer when you start. But for the rest of us, you need a set of rules of evidence and procedure to help sort cases into liability and no liability, responsibility and no responsibility. And that is, I think, the body of law and rules and norms that we really need to develop. And I'll stop there. Thanks so much.
Thank you, Professor Gersen. My question to the four of you follows almost precisely from where you were going and where you ended, which is to say that if there is a great interest in codes of procedure, as it were, it's not surprising that institutions like the American Law Institute have tried to step in to figure out what to recommend. And I want to read you just one draft recommendation and get your reaction. You can respond specifically to the recommendation, or maybe use it a little bit like a raw shot to respond more generally to what you've heard on the panel. If the complainant requests, and I quote, an informal resolution, colleges and universities should presumptively not insist on a formal resolution. Informal resolutions may be made available for the full range of misconduct. Why don't we start with you, Professor Rhode?
Is there transparency?
Say more.
Well, sure, from the standpoint of a lot of victims, that is what they want, and for many reasons, and I think that's the best outcome for everyone involved. But in order to establish, what is the best outcome, you need to have some level of transparency. And if everything's being resolved at an informal level and you have no idea what the agreements are, what the underlying facts were, what precipitated the assault, you're severely hobbled in dealing with improving the campus culture around sexual violence. So I guess I would say it depends what you mean by informal resolution.
Mr. Miltenberg?
I think what you're asking, or what I'm going to answer, is what role do universities play in the event that parties either want an informal mediation, or one party does, or I'm going to take it one step further. I started a case in federal court in Colorado last week on behalf of a gentleman named Grant Neal. Some of you, if you follow this area, may have read about it. Grant Neal was a very promising scholarship athlete, pre-med student, and he and his girlfriend had sex 2 times over 4 days. And someone else said, I think you were raped. And she said, no, please, no. And it went forward, and he has been suspended for 4 semesters. Forgetting he's a good kid, which he happens to be, she did not want to press charges. She didn't think she was raped. This is all on the record. Someone else thought she was raped. The school went forward with an investigation that would make everyone in this room feel ashamed. And that was the answer. And so I think the question really has to be that, and I don't have the answer for it, is to what extent do schools have a responsibility, notwithstanding what the parties may want.
Professor Dauber?
So there is some law around this, which is that, well, first of all, I agree with what Deborah said. But second of all, and when I was involved in doing the process here, during the first run, we did not allow for informal resolution because in general, Stanford doesn't like informal resolution of disciplinary complaints, and because we don't like plea bargains. When a student is charged, we have a tendency to not offer that. So I agree that there's a transparency problem. I agree with all of that. There is some law around this too, which is that the Office for Civil Rights does not allow mediation in cases of sexual assault. That is sort of the most serious kind of conduct. I mean, one of the problems is we don't know what sexual assault is, but in anyway, their guidance says
the next panel is going to figure that out.
Sexual assault. So just take whatever that means to you. They don't allow that. Now, mediation, they interpret quite narrowly to mean sort of being in the same room at the same time. I actually have myself a broader idea of what that means, which would include sort of shuttle mediation, you know. So I think there are problems around the definition of what's assault and problems around the definition of what's mediation, but just take that as a given that the Office for Civil Rights disapproves mediation. So some forms of informal resolution are not allowed. I also think that there can be problems with this with respect to campus safety generally, that it's not all about these two people. Often it is, but sometimes it isn't. And where the allegation is that there's a weapon, where the allegation is that there are multiple victims, where the allegation is that there could be an ongoing threat to campus safety, there I would not want informal resolution, because informal resolution essentially is a plea bargain. It could involve a very short or no suspension for conduct that if it went to a hearing, we would want to remove this individual from campus because he constitutes an ongoing threat in certain cases, assuming a fair process, blah, 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 okay, just picture the kitten. And so I think that, you know, under those conditions, assuming a fair process, assuming we would want this individual removed, there's, there's, even if she wants it all to go away, we have an obligation to all the other students out there. It's not all about her, you know, because I've been involved in cases where there were, in fact, multiple victims over a 4-year period from the same individual, and the first student wanted it to go away, and so didn't want to go forward, and we respected that, and then 3 more girls got assaulted. And so you have to think about that. We owe all the parents who send their children to us the same level of skill and care and protection.
Professor Gersen?
So 2 things. I think one is that just a point of, I guess it's clarification by way of question, or question by way of clarification. I think it's right that OCR says you can't use mediation for certain types, but I think they say it in the letter.
Yes.
Which they allege is a non-binding document. So when we say it's not allowed, we have to be careful. Is it allowed or is it not allowed? They're very clear it's not allowed, but they're very clear it's not allowed in a document they insist is not binding. So what schools are actually free to do is unclear in this regime, and I think that's worth noting. I was looking at it this morning, and as you say, it prohibits it, I think, for relatively narrow stuff, and it allows informal, I forget the exact language, informal resolution or something close to it for some class of undefined stuff.
Right, yes,
and so
yeah,
absolutely. Yeah. Just assuming that we're in this world of undefined stuff.
In guidance.
In guidance. I think part of the issue is that we're not sure what this domain is. Right. And we talk about it in these very confused ways. So are we describing criminal conduct? Because criminal conduct, we say the wrong is to the state, and it's a criminal thing. And some of this conduct would be criminal in the jurisdictions, and some of it is not criminal in the jurisdictions. Most of these actions are reported as crimes to the federal government in the Annual Security Act for purposes of reporting. They're described as crimes. They're not necessarily crimes, and they're not going to be treated criminally. They're going to be adjudicated civilly in this university context. If it's a dispute between 2 parties, the wrong is private, let the parties settle how they want. But as you say, in the university context, there is, I think, this concern for some subset of cases about the broader community, threats to third parties. And there, I think it's hard to imagine that we'd let the parties themselves always dictate that there would be a private or informal resolution, but I would prefer to keep it open for some class of cases too.
Thank you. Much more to talk about. You've put a lot of issues on the table. As you ask questions, it'd be very helpful if you maybe identify one or two members of the panel that you'd like an answer from.
Sure. First of all, I love kittens, so thank you for that.
I'm leaving.
Professor Gersen, both in his remarks and just now, talked about something that greatly interests me, and that is the intersection between what happens on campus and the criminal law, because sexual assault is a very serious thing. It is often criminal. So my question is, where the nature of the underlying allegation is in fact a crime, why are universities properly involved at all? And why the Dear Colleagues letter suggests that they have to do it, but doesn't have the force of law. Why don't we just get the university completely out of that business, send it into the criminal law context? It may take longer, but there's a presumption in the criminal law that it's going to be dealt with appropriately, that somebody's going to decide whether to make a charging allegation, and keep the university out of it, at least until somebody has decided there's probable cause to go forward with the criminal prosecution.
Thank you. Professor Gersen, you want to start?
Sure. So I think that, just to be candid, I was a little sympathetic to this view historically, and I've come to just not quite embrace it. And the reason in part is that even if there's going to be a parallel criminal process, as there will be for some of these cases, and as there would be for other kinds of crimes, arson, battery, I guess I feel like the university still is going to have to enter in a bit. So does the university have an obligation to keep the accused murderer or arsonist on campus and in class until and unless the criminal process unfolds? I suspect even in that context, we're going to say no. So the question is whether that university process, if there's going to be a parallel one, will run prior to, after, or in a concurrent way with the criminal process. And that, I think, is a much harder question, but I think it's hard to imagine that the university is just going to stop doing this entirely if it would involve criminal behavior, because that criminal behavior will also violate lots and lots of codes, norms, and possibly create a danger.
Professor Dauber?
I would just say, to add to that, if you go back to the slide, you don't have to show it, that Jacob originally put up that talks about Title IX, there is in fact a legal framework here that universities are in fact governed by. And so sexual assault is a severe form of sexual harassment. That's true in the workplace context. It's also true in the educational context. And universities, by accepting billions and billions of dollars, even if it's denominated private like Harvard or Stanford, still receives billions and billions of dollars of federal and state money and is subject to the law like Title IX. We have to prevent and protect our students from sex discrimination up to and including very severe forms of sexual harassment. So we can't get out of this space. Title IX applies to Stanford, it applies to Harvard, and we have an obligation to take action. I would just dispute the underlying premise that these things will be handled properly in the criminal law context. That's also not true. I just read about a case this morning from Oklahoma where they found that a woman who was sexually assaulted while she was unconscious, that oral sex perpetrated on someone who was, drunk to the point of unconsciousness doesn't actually violate the criminal law, apparently, of Oklahoma. So head to Oklahoma, guys. I mean, I don't know what to tell you. So I think that that is not true historically or currently, that sexual assault is always handled properly within the criminal context.
Mr.
That's an
Miltenberg?
overstatement.
I agree that schools cannot escape, nor should we expect schools to not be involved in this process at all. But from a practitioner's standpoint, when there is a concurrent criminal investigation and an ongoing Title IX investigation, I routinely counsel clients, you cannot say anything. You cannot defend yourself. I defer to criminal counsel. And that puts a student in an incredibly compromised position. And I haven't come across a good answer for that yet, except that I tell the student, listen, you have to lay down. There's nothing I can do to help you in this case. The minute you open your mouth, we're damaging anything that may happen in the criminal setting, and that destroys an opportunity to defend yourself on campus.
We're going to go to the mic on the left and then on the right.
Thank you. I'm Artemis. I'm a JD student here and a PhD student in the political science department. So there's a lot of consistency across the panel that we need more transparent processes and more consistency across those processes. And I think all reasonable people would agree that we have a huge false negative problem where lots of cases don't even come forward. And then from those that do, they face obstacles along the way, not least the evidentiary problem of how to prove it. And there's also potentially on the other side a false positive problem that if we go too far, they will start punishing people that perhaps shouldn't be punished or punish them more severely than they should be punished. So, however, it seems to me that before we agree on a consistency of process, we have to adjudicate the trade-off between the underlying values. And although everybody agrees that there are these values, sort of fair punishment on the one hand and making sure women come forward and have their complaints heard, people might disagree on how they weigh them, right? So this is what I want to ask you. Are we going to adopt a criminal law standard where we say, let 1,000 guilty men go free to not have one innocent person in jail? How are we going to think of the cost of expulsion, which sounds like it's pretty harsh for a lot of people, and we can't sort of ignore that it's severe punishment, versus the cost of potentially missing some of these cases and not encouraging enough women to come forward? So how do you think about this trade-off, and where should we draw the line?
Professor Rhode, why don't you start with that?
I don't think you can resolve that in the abstract. I mean, I think that is a great question. I think people differ in their views on these cases. And to articulate the trade-off doesn't, I think, advance the ball in terms of setting up appropriate procedures. You have to take both into account. And I don't think you can weight it on one side or the other. And in the conceptual design of the process, you want to be as impartial as you can to both sides. But you have to recognize, as someone said earlier, you know, these processes are implemented by humans who are imperfect and who come to the process with their own set of biases. And it's pretty clear to me now, having gone through training for being on the Stanford sexual assault, one of the potential panelists in these cases, that my co-panelists bring very different perspectives to the exact question that you posed in terms of very close cases. Which way are they going to see the ultimate fairness of the result?
Professor Dauber?
I think, again, it's really important to keep in mind that we have to compare this to other disciplinary matters that universities handle and ask ourselves why we think we need to answer that question specifically for this and not for other kinds of disciplinary matters. What is it about this that strikes us as the kind of thing, as opposed to, say, arson or physical assault or racial violence or religious, graffiti or something, that we think we need to know, we need a special rule for this?
First of all, stakes are higher than most of the other types of punishment. And secondly, the evidence is much harder to prove.
I don't think the stakes are higher. I mean, you would definitely get expelled if you painted a swastika on the side of the Hillel building. And you would be having to answer your question on graduate school applications. Have you ever been disciplined? Yes. For what? Please explain. And that would not be a good experience for you. And it would probably, sexual harassment would probably be a better thing to have been found responsible for in that context. I don't know, but I still think that the slippery slope, I mean, that's my answer to you, is that there is we need to be careful of deciding that universities can't decide disciplinary matters. Maybe they can't, but we need to be really cautious before we reach that conclusion. They are entitled to a very broad scope of deference, and I think the judges who are here today would probably be very happy to allow schools to have mostly that scope of deference as long as they're delivering a fair hearing. You also have to ask other kinds of due process questions, like, I can take away your Social Security benefits or your right to public housing. The state can interfere with a lot of different rights by giving, abilities or entitlements by giving, a fairly minimal set of fair procedures. And so, again, we just need to ask, what is it about this that makes us think that we really need to ratchet it up and legal it up, as Jacob said?
Professor Gersen, you look like you have a brief follow-up.
Just really briefly, I think we're confused about whether sex is different. And sometimes it is, and sometimes it's not in these discussions. The federal government has said it's different. said you have to do this way, it's different. So there is a message that is different. On the other hand, it shares lots and lots of features in these disputes with lots of other things that we do. And I'll just say this is part of the fight. And so the evidentiary standard was a huge part of this recent change. Many schools used a standard in between beyond a shadow of reasonable doubt and clear and convincing and proportion of evidence, and the government has said it has to be a proportion of evidence. If you use a standard that is too high to find responsibility that is a violation of Title IX, it is unlawful. And that's the thing that they've stuck to repeatedly over and over and over again. And there's no mystery there. If you lower the standard, you can get more findings of responsibility.
Mr. Miltenberg, brief
Just very
question.
quickly, the practical effect of that lowering to the preponderance of the evidence standard means that when the disciplinary matter starts, it is presumptive that the accused is responsible. The accuser presumptively is telling the truth. And all things being equal, the accused will be found responsible. And what I've found is that the cold comfort that the accused gets after being found responsible lies in the sanction, not in the finding. Meaning that the sanction may be lighter if it's really equal. And in the mind of the panel, that's how they reconcile the fact that they had to find responsibility.
Over here.
Yeah, a fascinating panel. I very much enjoyed all the presentations. I agree that this can't just be left to the criminal process, but I wonder to what extent what we see here may be influenced by, might reflect on the criminal and the civil processes. So one major difference is the criminal and civil process is public, with a very few exceptions. In some sex crime cases, you may be able to conceal the name of the accuser to some extent, but it is generally speaking public. It's a very, very firm rule. There are, of course, huge costs to it, both in terms of the possible humiliation that is felt, whether it's good or bad, but that's the reality, by the accuser, and what is felt by the wrongly accused, who, even if exonerated, might have this be heard by everybody. And of course, that is what the campus process seeks to eliminate. On the other hand, of course, there's a reason we have the public trials, in part because we wanted the process to be more transparent for the sake of information about how things are happening, but also because we feel that it may police better situations where it looks like the process is unfair.
Right.
So maybe public is just off the table, period, no question about it. We shouldn't ever even consider it at the college university level. But then the question is also what it tells us about the civil system. If I could just piggyback on that, because I thought that question was excellent. I mean, it seems to me we can't say, well, let's just have a system unless we know what the quantum of proof is required. And one way of articulating is, do we want it to be better that 10 guilty people go free than one innocent person be convicted? Better that 3, let's say, that would be clear and convincing, or better than 1, which would be preponderance of the evidence. And it may be that sex is indifferent, but presumably, we might say expulsion is different, especially if the expulsion, as Professor Dauber points out, carries with it essentially foreclosing from a profession for a long time. And so in the civil justice system, the criminal system, we have sometimes proof beyond a reasonable doubt, almost never in the civil context. For compensation, we have preponderance of the evidence. For punitive damages, we have clear and convincing evidence. For determination of parental rights, we have clear and convincing evidence. I don't know, by the way, how it is in professional licensing, what it takes to take away a doctor's license or a lawyer's license. Although that might actually be an interesting analogy.
Clear and convincing for lawyers.
So interesting. So if it's clear and convincing for lawyers, one might say if one is expelled from, say, law school with a notation that keeps one from going back to law school, one might say there should be also a clear and convincing standard. One or the other need to do one, or to choose something. So I'd love to hear what.
So that's an interesting point. I agree with your point about transparency, and I think that's why I brought up Yale. And I really encourage all of you to look at the Yale website, because I do think that we always talk about, for the very people, many of whom are in this room, who want to talk about criminalizing this process or emulating the criminal process. Remember public trial, and so I think that there is an aspect of that is very problematic in the educational context and is part of why we have so much distrust. On the second part of your question, which is about the burden of proof, I would just make the comment that I think you have some interesting ideas there, particularly having to do with expulsion. I would just make the comment to Jacob, though, that it isn't true that OCR has said sex is different. They would use the same preponderance if they were dealing with racial, investigation of racial harassment, Title II ADA harassment or anything else that they investigate. So it isn't true that they just lowered the burden of proof or insisted on a specific burden for sex cases. What they said is for discrimination cases, which are civil and carry civil remedies, we are going to use a preponderance standard. So if we were to use something higher for sex, we would be saying something higher than race, higher than disability, and that is why I'm saying think. You know, do you think this deserves a higher standard than, say, anti-Semitism?
Well, why not have for expulsion everything? Have the standard.
Well, I think that's a very interesting, I think that's a very interesting proposal, to look at it only where, you know, it's expulsion, clear and convincing. I don't know that I would oppose that on its face.
Mr. Miltenberg, any thoughts about that?
The preponderance standard has continually troubled me, and I don't think that is a reasonable standard to use in cases where there really only are two witnesses in most of the cases. And the evidence is very hard to come by, and I think it's an artificially low standard that, again, presumes a guilt and shifts the burden immediately to a respondent or accused to prove that something did not occur.
We're going to go to a question over here.
Yeah, Mark Hathaway, I'm an attorney in Los Angeles. As a father with 3 very active collegiate female athletes, I love Title IX. It's saved me a lot of money over the years. and now it's making me a lot of money because I can tell you I have some of the, anyway. If the purpose of Title IX is to make sure everyone has equal access to education, and the Dear Colleague letter talks about the colleges have an obligation to address issues where there's that create a hostile environment, why is that question never asked in most of these processes? So as an example, UC Davis, the investigator used to ask each of the complainants, after getting all the information, has this created a hostile environment for you? Have you lost any rights to your education? And if they say no, and many times they do, that's the end of it, because it doesn't create a hostile environment. And that might have been, for instance, in the Grant Neal case, if the girl says there's no hostile environment created, then why are schools merely investigating sexual actions between what it would be consenting adults if both people say they consent? And that would be, why not ask the question up front, did whatever occur create a hostile environment? If it didn't, it doesn't invoke Title IX.
Professor Rhode, we'll start with you and then hear from maybe Professor Gersen.
Well, I'll defer to Michele on this one.
Okay.
Well, in terms of whether it creates a hostile environment, many court cases have established the fact that one instance of extremely severe harassment is essential, like rape, is essentially a per se hostile environment, and that there is no burden on the victim to show, like a hardy victim who can still get high grades. This is how they often refer to it. If you're just a hardy victim and you can still get high grades and still succeed and still get promoted in your job, you still shouldn't have, it's a sort of a per se on its face hostile environment to have to be sitting next to the person, well, I won't gesture at you, sitting next to the person who who assaulted you. And that just because you can still get high grades as a result, you shouldn't be penalized in that way. That's the law.
Anything to add?
Well, I think this is a subject of disagreement and controversy. Not what you said, but I think the government has been pushing. I mean, always controversial, Michele, but the government has pushed schools, and I think we'll talk about this later today, in the way that they describe sexual misconduct and they characterize sexual harassment, which I do think is different than the way that the courts have done it. And so though the courts have said a single instance could be, I think that the tether to the hostile environment from the single instance is actually being pushed out of some of these definitions. So, that's my reading. I think the University of Montana Resolution Agreement looks like that. I think they've been pretty upfront about this. But whether you like that or not, I think the idea is that the relationship between an instance of sexual misconduct or sexual assault and the idea of sexual harassment, which is the trigger, the link to discrimination, is actually being thought about and argued about and contested, and that's changing actually quite a lot, I think, at the moment.
Later at the panel, Jeannie is going to talk about the shifting definitions and dynamics in sexuality, and I'm seeing that, quite frankly, and let me say something unattractive, that men are being treated very differently. And an example is a case that I'm handling unsuccessfully so far in the Southern District of New York, where I'm representing the gentleman, the young man who was the subject of the mattress, the carried mattress for 2 years. Emma Laskowitz and her mattress. She spent 2 years excoriating my client, calling him a rapist, calling for his expulsion after he was found not responsible by the school panel on several different occasions. And he was the subject of death threats. He could not go to the library anymore. He couldn't go to the dining hall. He was chased out of many classes. And that was a harassing environment. That was a terrible experience. It changed 2 years of his life. He was a pariah on campus. And the university let that continue, in fact, sanctioned it. They allowed Ms. Laskowitz to use that as her thesis and get credit for it and carry her mattress on stage. And recently, the Southern District, in a decision, said, well, listen, calling him a rapist and the fact that she was saying this and everyone, there were rallies on campus, really not gender-based, and there was really no harassment against him, and I just don't see it. And you can replead some of your causes of action, but I don't like this case. Now, we've repled it, and we filed a new complaint a week ago, but I'm concerned, and I used the example of had he walked around with a mattress saying Emma Laskowitz is a whore, and he did that for 2 years and held those rallies, I can't imagine he would have lasted that long on campus, and I can't imagine Columbia would have allowed it too long.
Over here.
I'm also going to respond to Professor Rhode's, some of her comments, and I have a certified sexual assault investigator.
Could you get closer to the mic? Thank you.
So I know...
That also helps because we're recording.
So from the inside, I have some kind of insight into the way these policies are being actually, how people are being trained, administrators are being trained. 4,000 people a year ago when I did the training, 4,000 administrators were members of this organization. Very quickly, I think what is missing from this discussion is that given the definition of sexual assault that is being used on hundreds of college campuses, we're seeing the feeling here in this discussion is, oh, there isn't any uniformity, but there actually is. And if you look up the ATICSA model definition, hundreds of schools are using this. And it means, and given this definition, every single person in this room could be accused of and held responsible for sexual assault. It includes a touch anywhere on the body. It's done with sexual intent. I told him that he was cute and without consent. He didn't like that. It's annoying. It is annoying, right? He doesn't object.
I don't want to rush you, but I want to be sensitive of everybody else trying to ask a question. So just the question is reality. The question is,
even if it doesn't object, if he tells a friend, the OCR, I think it's in the Dear Colleague letter of April 4th, 2011, which is when everything's flipped. It's hearsay is called outcry. They said we're going to admit hearsay is outcry. Using this definition, everyone can be accused of sexual assault. Include also, if you look at the studies very carefully, you say that people have a fear of reprisal, but actually one of the reasons that women don't...
Can I just ask you to frame it as a question for a particular cause?
Are you aware that... that in the studies, there's an excellent study, December 14th, Bureau of Statistics, Department of Justice, I don't know if you're aware of the study, the panel. The women was said, or men, but mostly women, say, I was drunk, I had sex. They don't call it sexual assault, but the researchers do. They also perceived threat is considered sexual assault. That goes in the statistics. Finally, you say the OCR isn't afraid. This is after the, obviously, up to the Dear Colleague letter. I think they were not afraid. Campuses were not afraid. Schools were not afraid of the OCR, but I think they are now. If you look at the Michigan State University decision, they come in, they occupy for years. Oh, maybe okay. You're not aware of this.
Well, actually, we're just going to get a comment on that. Why don't we start with Professor Rhode?
Am I aware of the particular study? I guess that was the question that was embedded in there somewhere.
That there is a common definition that the reason people don't report that is that, are you aware that in the studies, the researchers themselves label something sexual assault the women that have not?
Well, that's
2007
part of the reason.
study.
As I read the research, and I've looked kind of carefully at a number of studies about why victims don't report, and I know Michele has as well, one of the reasons is, yes, they didn't consider it rape, but all of the other things that I mentioned, the fear of retaliation, the fear they won't be taken seriously, the fear of ostracism and vilification, all of those are factors.
Anything to add? Yeah,
Yeah, I just want
Professor
to say,
Gersen?
although there is, I think, a lot of conformity in some of these definitions, when you say the definition, there is no the definition. If you read the statutes,
being used
if you read the
across the country,
statutes, the definitions are multiple. The regulations, definitions are multiple. The codes, the definitions are multiple. And part of what we're trying to have at the moment, is a political and public, call it a discussion or disagreement or fight, but a discussion about how we want to define conduct that is permissible and not, and how we want to respond to the conduct that we have defined in that way. And my view is people disagree a lot about this. I have a view, but we should be having it transparently and
But
openly.
I think the premise should not be that
rather
there is
than
a common
substantial.
definition. If you look, hundreds of schools are using this definition, which includes the touch. And you combine that with the OCRs.
Definitely, and some are much
guidance.
more expansive than that. But the point is we should be fighting about what they are.
We have a
Definitely.
Ninth Circuit judge waiting.
So we're
We
gonna
don't
come
want
over
to keep
here.
a Ninth Circuit
Thank you.
judge
No, no, no.
waiting.
I just have a few more things to
Okay, all right.
Much of the conversation this morning has been about procedures or the lack of clarity or transparency procedures, and an attempt to try and find them, and they differ among universities. But let me ask, if I could ask each of you to go back a step behind it, what is the object of the procedure that you want to develop? When I was a youngster in law school, actually in this university, we discussed criminal law in terms of rehabilitation, deterrence, both specific and general, and retribution, and helped guide us figure out what we wanted to outlaw and how we would punish it. So what are the objects of the process that a university should be concerned with? And obviously the universities may disagree, but I'd be grateful because you may have very different views about this, and that would then affect what you see the procedure would be. Because the procedure, I think, would follow from what your object is. So, for example, I think, Professor Rhode, if I'm wrong, forgive me, part of your concern was, for a long time, not just on university campuses, but across the country, sexual assault, broadly defined and narrowly defined, was not taken seriously, which had lots of implications across the community. It is now taken more seriously, in some places, not very much. The outliers of Oklahoma will leave aside. But in California, some places yes, some places no. So if the question is what we want to do is make the awareness, if that's the object, then you design a procedure differently than if you want to say we want this person out of our midst. And obviously you could have multiple objects. But I think that would be important, and I'd be grateful if you could share your thoughts about what the objects or goals, so to speak, of the process would be. Thank you.
Professor Dauber, let's start with you.
First and foremost, my goal is a safe campus. So first and foremost, that's what I'm interested in. And I do think to some extent that we really do need to stay with our feet on the ground and use our common sense about how serious the threat is that we're talking about and what kinds of reasonable steps universities should take to protect student safety. So that's my first goal. And then my second goal, of course, is to comply with the law and to protect students' civil rights, because that we're required to do, and I think that's important. And that has to be done through a fair process. Again, what is a fair hearing sort of constitutionally is, notice and an opportunity to be heard, okay, at its most basic level. Now, we may feel that in the university context that for expulsion, like Eugene said, maybe we want to have something that's a little bit more robust, but if we, as I said at the beginning of my talk, if we get too robust, we're going to impair our ability to have a safe campus. We're going to be surrendering our common sense at the door, which I really don't want to do, and we're going to create something that not Stanford or Harvard, but like the average school cannot do, as Jacob said. We're going to hyper-legalize a situation that is fundamentally educational, and we're going to put a burden on, say, Foothill Community College or Oklahoma State that they can't possibly meet. And I don't think we have thought this all the way through yet. So yes, you're absolutely right. What is our goal? Our goal is a safe campus. That has to be first and foremost.
Mr. Miltenberg?
I don't have anything necessarily to add to that.
Okay. Jake?
I think my aspirations are for a procedure like this are accuracy, legitimacy, and education. And I think that's what we're doing here. So if it depends on factual determinations, we should try to be accurate as possible. and I think treat all the parties with respect and dignity and have it be a legitimate process that we would watch and be proud of and participate in and be proud of. And I think to ignore the educational role that these tribunals are serving is impossible. We are describing a set of things that we want to be permissible or impermissible. We're regulating conduct, and there's a ton of prevention programs that are the precursors to this process. We're defining conduct, we're going to try to prevent it, and then we're doing the discipline. But those two things that come prior in the process are related to the educational environment that we want to live in.
Professor Rhode?
I agree with that and with Michelle's comments.
Thank you. Over here.
Well, I want to go back to what I think was a really important question about false negatives and false positives. The discussion about that so far, as I understand it, is basically said, we have serious consequences for people who do other bad things. Why would this be any different? You know, the analogy that Michele Dauber said several times, the swastika or whatever. And a lot of discussion about whether the difficulties of having the tribunal in hindsight know what happened might or might not justify a different standard here. I think there's an additional element in sex that hasn't been talked about, and my question will be after I describe what I think it is, whether you, the panelists, think that might affect how we approach the question about false negatives and false positives, and that is that a subset of sexual offenses, particularly under the increasingly expansive definitions that are indicated in Professor Dauber's table and the ALI is now proposing and so forth, a subset of them involve conduct that I think we can fairly say is morally and emotionally ambiguous at the time to the participants, leaving aside the alcohol problem. And so an additional factor would seem to me in considering the false negative, false positive trade-off would be not only how difficult is it to know, for the tribunal to know in hindsight what happened, but also how difficult is it for the actors cognitively and emotionally to be responsible for the line drawing in real time. And is that something that we should take into account in this trade-off?
Thank you. Professor Dauber?
Well, I think that the analogy that I would ask you to think about is fraternity hazing, because I think that fraternity hazing shares many, many things in common with sexual assault. It happens often without witnesses. It is by definition secret. It involves shame. It involves power and domination sometimes. It involves making people do things that they otherwise wouldn't do, and it is ambiguous sometimes to the people at the time that it's happening. They don't really realize that they didn't feel good about it or that it was wrong until later. So, or when it comes to light and the community gets a look at it and is like, oh. And so I think that, again, this exercise in line drawing between sex and everything else is not as easy as it may feel to people in the moment.
Mr. Miltenberg?
You know, respectfully, I think that the question really was one that's incredibly pertinent, and is at the time and thereafter, how often can the actors, the participants, discern what happened? And there is no bright line. There isn't necessarily a power exchange. Hazing, and I was in a fraternity, and we knew when we wanted the pledges to come there and we were going to throw eggs at them. That was hazing. We knew it, but when these young people leave a fraternity party together and get naked in bed together, and one of them gets a condom and the other sees that as an invitation, and there is no, are you sure you want me to penetrate you? But there is everything else that we would read as nonverbal cues as consent. That's where the line gets very blurred, and that's where I think the difficulties come for the panel, because very many of these, for me, have ended with not, and I said this earlier, not knowing at the end any better than I did when I first spoke to the client what really happened. So that may not be an answer, but what you've brought up is something very significant that is not being addressed.
So we have 9 minutes and 2 questions left. What I'm going to suggest is to have His Honor ask the question, and then we'll let you raise your question as well, and I'll give the 4 of you a chance to close.
This
questions. Okay, we'll try to squeeze in the 3rd question. Thank you.
This question goes to Mr. Miltenberg and Professor Gersen. At the risk of being labeled a textualist, I saw on the on the screen that the Department of Education requires the procedures to be, quote, prompt and equitable. My question to you, Mr. Miltenberg and Professor Gersen, is, has any litigant in a school disciplinary action brought an action in declaratory relief and for preliminary injunction to enjoin the disciplinary action by relying on the language prompt and equitable and saying it's not equitable because these procedures don't exist?
Don't answer yet. Let's get the other questions on the table. Go ahead. Briefly, brief question.
Okay, yeah. I have a quick question for Michele, and then I have a quick follow-up. So, Michele, I listened to you speak a lot about transparency and information, and I heard you say over and over, you know, there's a lot we don't know. And I just wanted to know if you're interested in what the FBI and DOJ say for their data on rape statistics.
Yes, of course I am.
Okay, and so what is it as you believe it?
Hold on 1 second. Let's get the last question on, and then we'll let them answer.
Wait.
Yeah, I just want to make sure that everybody has a chance to ask the question, and then we'll let them answer. Go ahead.
None of the comments today really focused on what was going on if it's not student-on-student assault. What if it's a professor on student assault, where you now remove not necessarily just the social stigma that goes along with it, but the power play? And that professor or someone of power, whether it's a thesis advisor or something like that, now enjoys what seems like immunity and impunity because they carry research dollars. They bring in the research money. They bring in the name recognition. And now it's just a student working on their undergrad, their PhD, their MD, their JD. What's going on about looking into harassment and assault by people in positions of power and who administrators are looking the other way and the students are really intimidated and chilled?
Thank you. So we have 5 minutes and 4 panelists.
But my other question specifically had to deal with Michele when she was talking about wanting to build an agreement between people.
We'll get it on the table and we'll let them answer.
Okay, and I wanted to know what she's talking about when she says agreement, because I heard her, I would watch her squirm so much when Andrew was speaking. And so what is she calling for an agreement between what?
Okay, thank you very much. Why don't we start with you, Mr. Miltenberg?
Okay, so Judge, where are you? So the answer is that most of the matters I've handled have gone on for months and months, and every time I've raised with the school panel that this is taking 6, 7, 8 months, and your code of conduct says it'll be 30 to 45 days, and the OCR says it should be prompt, they take the view that it's my complaints are de minimis and the ends justify the means. And tactically, the concern is that we haven't exhausted administrative remedies, and so my concern is always that if I go to court and spend the effort and time and energy and money to draft an injunction without having those administrative remedies be exhausted, that a judge will tell me, come back to me when you have a result. You're in the middle of the process. Although I can't say that we're in the middle of trying that in a case at Cornell, and I'll let you know how it goes. I'm not sanguine about it, but my hope is that it may work. And very quickly on the faculty, I've represented half a dozen faculty members, and interestingly enough, in allegations from students to faculty members, and the standard of proof, at least at the schools that I've worked with, and the process is very different than the student process. The standard of proof is higher, and quite frankly, I'm much more comfortable and feel much more calm when I'm representing a faculty member. The evidentiary standard is higher, and it may just be my limited 6 or 7 experiences doing that, but there is a great amount of deference given to the faculty member.
Thank you. Professor Dauber.
On the subject of faculty harassment of students, I think that I agree with what was just said, that the process is often much more deferential. Of course, the stakes are much higher too. You have someone losing, say, a tenured position at a university versus someone maybe having to
just
transfer.
Right,
so the property right that's being protected there may be somewhat higher. In terms of the what's known, not enough is known. There's definitely not enough transparency around this issue. I think the University of California, what's happening there should be an object lesson for schools. Like, I've been personally involved in cases at Stanford that are just as bad as the ones that are being exposed at Cal, and in some of them, but because Stanford is private and not subject to the Public Records Act, this information isn't making it out into the public. I think, though, there's a real gap between the way the public sees this kind of sexual harassment and the way university administrators who operate in their tiny little, echo chamber world of groupthink about how it ought to be handled. And so there's been a sort of a kick the can down the road and mentality, warning letter in the file kind of a thing. And when it leaks out into the world, people are like, I don't agree with that at all. And so I think more transparency again around this is the solution.
Professor Gersen?
Okay, briefly, I don't know of any challenges to the prompt and equitable directly. It's a plausible challenge. I think you'll see a few APA challenges, but they haven't been yet, and universities have not been excited to do that and stand up against the OCR. We talked about these trade-offs and complainants and accused and too much or too little process. I actually think that we're far, far in the interior here. So we're not on the frontier where we're just going to trade off a little more liberty for a little more security or a little more plaintiff preferred, a little more defendant. There's a lot of improvement here to do, which would advantage, I think, both sides. And then third, again, I'm completely in agreement on the transparency issue. I just want to note that just like knowledge is power, a lack of knowledge is power too. And there are lots of people in the system who actually, I think, would not prefer that all this information come out, all of this be made transparent, and we should be attuned to those dynamics as we think about reform as well.
Mr. Miltenberg, you had a brief last comment, and then we're going to go to
Yes, as far as
Rhode.
transparency, I invite everyone to be co-counsel with me on my next case, because it'll be incredibly apparent as to what's going on, and that's all I was going to add.
Professor Rhode, you get the last word.
Well, I'll take it to issue a thanks to Judd, to Michael McConnell, and to you. I think it's really hard to have a discussion on this issue in which people listen to each other respectfully and engage with our best estimate of the facts. And I think that happened here, and a lot of credit goes to the organizers of this conference and our moderator for making it possible. So,
thank you.
Thank you, Judge.